Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small actual criminal law firm in central Minnesota. What's up today? How are you guys doing? You may or may not know that I'm streaming the Karen Read trial currently. It was day 26 earlier today, day 26 of the Karen Read trial. And, you know, the trial itself takes up most of the day. If you are interested in trial streams and didn't know I was streaming, I stream pretty much every weekday right now at 8 a.m. and I Central Time, and I go until about 4 p.m. Central Time. That is kind of the schedule of the trial. So if you want to join us, please do. You know, there's a significant amount of downtime during these trial streams because there's a morning break, an afternoon break, there's a lunch break as well. And then they have sidebars and sometimes they have to have an argument outside the presence of the jury or outside the earshot of the jury. And so you're just kind of the chat and I are sitting around. And today a chat question came in through super chat or something like that, super chat or super tips. And someone asked me about Turner v. Safley. Turner v. Safley is a Supreme Court case. And I fully admit I wasn't familiar off the top of my head with Turner v. Safley. I wasn't familiar with the citation and what it stood for. It's not a case that I had to utilize in any way in my practice. And I probably covered it in law school, but I don't particularly remember it. But that being said, they asked about Turner versus Safley and the Turner test. And what Turner versus Safley is it's basically a case about the ability of a penological institution, typically a jail or a prison, which is going to restrict a fundamental right of an inmate or a group of inmates or whatever. So a right like speech or something like that. And they need to pass the Turner test. So, you know, a viewer asked me about what Turner versus Safley stood for, and I went ahead and gave them an explanation that you can see right here. I just wanted to introduce you to it, and you know, you can it's gonna clip over and show a replay of that section of the live stream. But take a moment, learn about Turner versus Safley. It's pretty cool case with some pretty cool principles behind it and some interesting parallels to other areas of reduced privacy and reduced constitutional rights. And then, if you like that, come hang out with us during the live streams of the Karen Read trial. You know, we have serious legal discussion. We also have silly shenanigans like making AI songs and AI art to have fun, to poke fun at people, to poke fun at the world, and you know, just generally kill the time that is between the trial affairs. So hope to see you there, and I hope you enjoyed this explanation of this landmark Supreme Court case. Until next time, I'll see you later. Peace. Oh, so there's a super chat earlier asking about Turner versus Safley. I wasn't familiar with the case, but I'm familiar with the principles surrounding the case, and I can talk to them. So Turner versus Safley is a case from the 80s, 1987, and it's a standard for the infringement on the rights of prisoners, inmates in you know, state institutions. And so if you're going to restrict a constitutional right out in the wild, out in the world as a government, you have to pass various levels of scrutiny. First Amendment rights, for example, require strict scrutiny. So the government has to have a compelling government interest, and the restrictions on speech, for example, would have to be narrowly tailored to sweep up only unprotected activity. So stuff we've seen around this is stuff like defamation, for example. So defamation infringes on the rights of another person. It's like it's akin to an assault that's used with words. It's meant to harm someone's reputation, through a falsehood. So that's not protected speech. The First Amendment does not protect your ability to lie about someone to cause them harm. All right. However, if you're going to have a law restricting the use of any speech, including a law that would, punish defamatory speech, it would have to pass strict scrutiny. You would have to say, like, you'd have to make sure that it's not implicating or it's not impacting or removing otherwise protected speech. And that's why there aren't many criminal defamation laws. Actually, it's really hard to do. It's really hard to say that you can't quote unquote defame someone. And so we're going to have a criminal punishment, because that would necessarily be sweeping on a whole bunch of protected activity, and it would have a chilling effect on protected speech. So most of the criminal defamation statutes get really, they get hyper specific, and many of them just aren't functional anymore. So they just let the civil remedies take hold. It's really dangerous to give the government the ability to punish people who speak falsehoods against someone criminally, because then they start arresting people who speak out against the government or a government official, and then that starts to look kind of like corruption. So that's how it works out in the wild. But in a prison system, and similarly in a public school setting, these are actually very the case law around these two things is very similar. In the prison setting, you don't have the same level. You have every constitutional right, but the ability of the government to truncate them in the prison setting is elevated. And so the standard drops down to a rational basis standard. So you get rid of that whole strict scrutiny idea, and now it's rational basis. And they developed a test. It's called the Turner test. And the Turner test is it's just laying out how the rational basis works. So rational basis means that the infringement on the right has to be rationally related to a legitimate government interest. In this case, it would be a penological interest, which is the management of a penal system. So there has to be a legitimate penological interest. So the way you could think about this with the First Amendment, for example, is where otherwise you could say, maybe you could say a racial slur or epithet. You could actually see a penal institution restricting race-related speech, and saying that there's a penological interest because that race-related speech fuels violence between the racial gangs that are in the institution. So the factors of the test, according to the internet, and I'll take it at its word that this is correct, and I'll just because all of these things look perfectly okay. So it says a valid rational connection. So the regulation must have a clear connection to a legitimate penological interest. Alternative means. Inmates should have alternative ways to exercise their right if possible. But this, the if possible is literally if possible. If there's a clear and obvious way for them to exercise their right, they should be able to do it. Like maybe they can use racism in a racism room or something. That'd be great. Impact on the prison. The regulation should not cause excessive ripple effects on prison staff resources or other inmates. And that's just kind of an extension, in my opinion, of the valid penological interest. Is like it shouldn't be disruptive. The whole point is the overwhelming penological, and it's not because I just like saying penological over and over, but the whole point of the penological or the penal system is to regulate a certain group of people's behavior who have forfeited the full access to their rights and privileges. You would suspect that if the exercise of these things is negatively impactful to the ability to manage this group of people, then that's not going to work out. The primary function of the penal institution is to regulate and control these types of people who have been deemed unfit to be in society, at least for a period of time. So, and then the ready alternative, if there's an alternative way to achieve the penological interest, the regulation must be or may be less likely to be upheld. So if there's another way to do it, like let's say they say, no, you can't, prisoners can't have signs that have words on them. because those signs become weapons, right? So there's a penological interest. Well, is there a different way to allow the prisoners to have expressive speech that doesn't violate some other rule? Is there another way to do it? They can't have like a sign with a picket because that becomes a dangerous weapon or whatever. But can they just can they create like just a paper sign out of writing paper, for example? Is that okay? Are they allowed to display that on the inside of their cell or even on the outside of the cell bars? Like, can they do something like that? And if so, that needs to be an available alternative means to the other exercise of speech that they would have. This is similar to how they work with public schools, right? Because there's an educational purpose, and that's the primary purpose of a public school is to provide and facilitate the education of a group of people. So the exercise of rights may be there, but if that exercise of rights interferes with the institution's primary purpose, which is educating children, then it will be limited, which is why, there's a Fourth Amendment right to privacy and, or I shouldn't say privacy, but a Fourth Amendment right against unreasonable searches and seizures. But yet schools conduct locker searches and seizures all the time because if they had a fully exercisable right where they required a warrant to enter into a student locker, for example, then they would be at real risk of allowing things into the school to be stored in the school that interfere with the educational purpose of the institution. And if they do that, then what's the whole fucking point of sending kids to school? So they have a broader ability to breach the Fourth Amendment rights against search and seizure. And the way it kind of works out is just an expanded question of what is reasonable in the context of the institution. It's the same thing with the penological interest, right? Like you do not have Fourth Amendment protection against search and seizure in almost any instance inside a penal institution. Like they have the right to search you. And that's because the penological interest in maintaining a safe environment that, is less likely to produce a stabbing, that trumps the we'll say forfeited or suspended right to freedom from search and seizure that the inmates have. But there is some level of cause that they need to do a search, or there should be. I don't think they really exercise it, and the level is really low. Like, I don't think it's even up to probable cause, But anyway, I hope that helps explain it. But thank you for asking.